the Companies Act general provisions with respect to articles. That would be those would be the articles of incorporation. Section 19, effect of articles. Subsection 1. Subject to the provisions of this Act, the articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed and sealed by each member, and contained covenants on the part of each member to observe all the provisions of the articles. Subsection 2. All money payable by any member to the company under the article shall be a debt due from him to the company, and in this island be the nature of a specialty debt. Section 20. Provisions as to articles of companies limited by guarantee. So those limited by guarantee would be non-profit entities. Subsection 1. In the case of a company limited by guarantee and not having a share capital, every provision in the article or in any resolution of the company purporting to give any person a right to participate in the divisible profits of the company otherwise than as a member shall be void unless each provision was in existence at the appointed day. So, read that again. In the case of a company limited by guarantee, not having a share capital, every provision in the article or in any resolution of the company purporting to give a person a right to participate in the divisible profits of the company otherwise than as a member shall be void. So therefore, it is not allowed for persons outside of the company to come and invest in it. Now, invest in it for profit. It's a non-profit company. So, it shall be void unless such provision was in existence at the appointed day. Subsection 2. For the purpose of the provisions of this Act relating to the articles of a company limited by guarantee, and of this section, every provision in the articles or in any resolution of a company limited by guarantee purporting to divide the undertaking of the company into shares or interests shall be treated as a provision for a share capital, notwithstanding that the number of shares or interest is not specified thereby. So, here, for the purposes of this provision, the provisions of this Act relating to the articles of a company limited by guarantee, every provision in the articles, be written in the articles, or in any resolution of a company limited by guarantee purporting to divide up the undertaking of the company into shares or interests, that will be treated as a provision for a share capital. Section 21. alterations of articles increasing liability to contribute to share capital, not to bind existing members without consent. Notwithstanding anything in the articles of a company, no member of the company shall be bound by an alteration made in the articles after the date on which he became a member, if and so far as the alteration requires him to take or substitute or subscribe for more shares than the number held by him at the date on which the alteration is made, or in any way increases his liability as at that date to contribute to the share capital of or otherwise to be paid to the company, provided that the section shall not apply in any case where the member agrees in writing, either before or after the alteration is made, to be bound thereof. So if the directors make alteration to the article, for example, requiring a certain member to hold a different amount of shares than what he or she holds, and if that member does not consent to such a change in the article, then that change is not to take effect on that member. So you as a member, you are not obligated to invest more or to owe more money to the company just because somebody else adjusted the articles without your consent for them to do so. Section 22, copies of articles to be given to members. Subsection 1. A company shall, on being so required by any member, send to him a copy of the articles subject to payment of such sum as may be prescribed. Subsection 2. If a company makes default in complying with this section, the company and every officer of the company who is in default shall be liable to a fine not exceeding $2,000. So, when a member of the company make a request for a copy of the Articles of Incorporation, that member should be given such a copy of the articles. I am not seeing a timeline here within which you must present that copy of the article, but it must be done, I guess, in reasonable time, or time in which the court, a time which the court or the judge would consider to be reasonable. Membership of a company, we'll look at that in a different video.